Hello, towel friends. My name is Grant Smith Ellis. It is absolutely wonderful to be with you all today after day 27 of the John O'Keefe and Karen Reed retrial. There was just bombshell after bombshell after bombshell. First, the state submitted their proposed model jury instructions as the defense case begins to get near its end. And ladies and gentlemen, the state will be moving for the consciousness of guilt jury instruction against Karen Reed in regards to witness intimidation and evidence destruction. Oh, ladies and gentlemen, that is bad as can possibly be. But if that weren't bad enough, ladies and gentlemen, you may have heard it from reporters in the courtroom like the wonderful and venerated John DePetro or myself, Little Towel, that there is a sentiment among this jury of pervasive dislike and disdain for Karen from all the jurors, a young jury, a jury who appears not to have been poisoned by the FKR, Free Karen Reed virus, ladies and gentlemen. My goodness, let me tell you folks, you could palpably sense the Karen Reed defense sinking. You could see the good ship Hinden Reed collapsing in real time. Oh, the humanity, ladies and gentlemen. Bob Alessi literally moved for a mistrial, a sign that not only is the defense worried about a conviction, but they're worried about a conviction from this specific jury, ladies and gentlemen. Why did they move for a mistrial, ladies and gentlemen? They ended up getting humiliated, the Karen Reed defense, because Bob Alessi said that Hank Brennan brought up the lack of dog DNA in the case during the cross of defense expert Dr. Marie anti-gravitational, non-DNA having dog expert Russell. Okay, ladies and gentlemen, Bob Alessi lost the motion for a mistrial, and then Bob Alessi lost on the issue as to whether Hank Brennan could ask Russell about the lack of dog DNA in the case, and then Hank Brennan brilliantly asked Dr. Russell about the lack of dog DNA in the case. But that wasn't it, ladies and gentlemen. We then came back from lunch, and a Dighton police officer who tried to testify for the defense got his soul ripped out by Hank Brennan and was forced to basically prostrate himself in front of Mr. Brennan and apologize for his lack of memory. He basically, the police officer testifying for the defense, got up there and told Hank Brennan that he had a terrible memory, had no idea really what he was testifying about, and that his testimony changed and that his memory was bad. So, ladies and gentlemen, it's one thing after another, and we are here to talk about all of it. You know we are, ladies and gentlemen, of course, because I would be derelict in my duty to you as a towel if I were to do anything but. And do you really think, ladies and gentlemen, that I am going to let the towel friends from over 87 countries around the world and all the towel friends on X down after a day in which we listened to 8 hours of testimony? What about the towel friends who had to work and didn't get to watch 8 hours of testimony? What about the people who don't like listening to Bob Alessi? What about the people who have to do things, ladies and gentlemen? Oh, goodness. And what about our dear friend who Towel is going to defend, Andrea, who Towel was an idiot about yesterday and now is profusely apologizing to? Yes, ladies and gentlemen, sometimes those people need to take part in the recap, even if Towel inadvertently banned that person for 24 hours and now feels like an idiot. Okay, ladies and gentlemen, so that is why we do our recaps, and we're going to start right away with the thing that began the day, ladies and gentlemen. We're going to take a look at the model jury instruction as proposed by the Commonwealth, ladies and gentlemen. We have so many towel friends in the chat. There is nothing better, ladies and gentlemen, than being able to look at the moment that the consciousness of guilt instruction was announced in the John O'Keefe and Karen Reed retrial. Oh, ladies and gentlemen, you can see it there. I'm going to zoom in on it for you right now. We're going to read the operative part, ladies and gentlemen. We are going to read it. I have the file right here for you. It is a PDF file. I am a towel, and you can see it is a bunch of pages, but we are going to narrow in on an operative part. If you missed the overview of the elements of the charges against I strongly advise you to read this document. You know what we're going to do, actually, towel friends? I'm going to grab this. I'm going to head over to the towel chat. If you want to follow along with this document as we do it during the recap, there's nothing like Towel Stream, because, look, where other than Towel Stream, before you even hear that I'm providing you a link to the document, you look down in the chat, you click the Google Drive link, and what does it bring you to, ladies and gentlemen? Oh, yes, it brings you to the very Google Drive link that we are now reviewing on stream. It is the most unique Tesseract-like experience in the world, ladies and gentlemen. A real-time stream that interacts with you, ladies and gentlemen, and the new towel microphone is on the way, and it should be here by at least tomorrow morning, at the latest tomorrow morning, hopefully tonight. And then, ladies and gentlemen, I will be able to operate the towel stream without having to hold up this stand, and I can't even use use this stand because the arms are so weak they don't work anymore. Towel has had this microphone for over 8 years. I don't think you understand, ladies and gentlemen. It cost like $30. It lived a good life. God bless you, little microphone. I think I can bless a microphone. Anyway, so here's the proposed Commonwealth jury instructions. It starts with an overview of the charges. Then we go in. Now, here's what's unique about what they're proposing. So this murder in the second degree in Massachusetts doesn't require intent to kill under the third prong, and it's a 3-part or test. So note that you don't actually need all 3 of the prongs: intended to kill, intended to cause grievous bodily harm, or. So it's or. What the Commonwealth wants is this last one. Karen intended to do an act which in the circumstances known to the defendant created a reasonable person would have known created a plain and strong likelihood that death would result. Now here's where Brennan gets a little unique with it. We go down to the bottom of the page, right, little towels? Hold on 1 second. Don't think I'm not moving those numbers away. Ted Daniel, I am up 2-1 on the scoreboard, and you will enjoy every minute of it. Anyway, ladies and gentlemen, I apparently talked about Sue O'Connell on the stream the other day, and someone told me I didn't read it. She responded. That means the traditional media is like, oh no, he is bigger than our stations. We have to watch him when he talks about us. So, Sue O'Connell, you rub the arms of Karen Reed's parents, and I have video of it. And I have a bigger platform than your station. Ha ha. Anyway, so Hank Brennan has his relative. I'm hilarious. Hank Brennan has this relatively interesting footnote here, which says that the state wants only the instruction on the third prong, and that'll reduce confusion for the jury. This is a brilliant move by Hank Brennan, ladies and gentlemen. Simply brilliant. Everything Hank Brennan does in the mind of Little Towel is brilliant. Oh, but ladies and gentlemen, there's a certain point where Hank Brennan's brilliance just comes through and just totally blows me away. And limiting the jury to just consideration of the third prong of the malice second-degree murder. Yes, Mandy Strong, I can do that. Just doing that, ladies and gentlemen, was amazing. Also, Pug and Spice and Rebecca Hayes, enjoy your new gift memberships. Ladies and gentlemen, we have a backlog of gift memberships. So if you go into your Towel channel settings and enable gift memberships, oh, ladies and gentlemen, you will be able to join that flow. Now, let me tell you, folks, I am going to make a note here for Mandy Strong. Show tail light broken. We'll do that as soon as we're done here, Mandy Strong. So you can see the state wants to only read the third element of the malice second-degree murder charge to the jurors. That's a brilliant strategy by Brennan. Really simplifies a complex process because a lot of people think that murder requires intent. It does not require intent to kill. It can, in Massachusetts, for a malice theory of second-degree murder, require only intent to do an underlying reckless act that a reasonably prudent person knew or should have known in the circumstances pose a strong and plain likelihood of death. All right, so now we can take a look. That's the first charge, and now that's the longer the element of the first charge, the third prong that the state wants read. And so you can see here, ladies and gentlemen, it says pretty simply, the third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. So, ladies and gentlemen, that's really the most important overview. Then we get the elements of the operating motor vehicle under the influence of manslaughter will OUI charge. That's a very important charge to review. 5 elements, ladies and gentlemen. Operated a vehicle on a public way, was intoxicated, and or had percent of alcohol at 0.8 or greater. The state wants both of those read because it's an or thing, so you could pick both or either one. Fourth, the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. So it's very similar. You might say, what's the difference between that and the malice theory of second-degree murder and the third prong that says a reasonably prudent person knew or should have known what had caused a strong and plain likelihood of death? So it's basically like malice second-degree murder is the act plus a theory of the act, and then here it's more like the defendant operated the vehicle wantonly or recklessly. Wantonly is a little bit lower than recklessly. Recklessly is a mens rea that's like relatively moderate. It's kind of like knew or should have known. And then wantonly is kind of like doing something that could cause danger to the public at large, which is lower than recklessly. Wanton is a very specific word. It's not a food. It's like wantonly doing. It's a kind of a civil standard, but it does exist in the criminal context, and it's more like would a reasonable person think this would pose a risk of harm to the public? And so, like, I don't know what's a good example of that. Like setting fireworks off in an open field that's dry or something. That's wanton. Reckless would be like setting fireworks off in an open field and pointing them at someone while you do it. And then fifth, the operation of the motor vehicle caused the death of John O'Keefe. So that's OUI manslaughter. And then another one of the charges is involuntary manslaughter. I don't know if I think they do have that in here. I don't know if they actually read the elements. And then that we go right to the elements of guilty, leaving the scene of an accident resulting in death. And then that has 5 elements, very similar: operated a motor vehicle on in public way, collided with John O'Keefe, collision caused injury to John O'Keefe resulting in his death, and then Cairns didn't stop and then left the scene to avoid prosecution or apprehension. Then you get the use of the dangerous weapon, motor vehicle instruction proposed by the Commonwealth. What's not evidence? That's pretty standard. Evaluating the evidence, jurors, charts and similarities not in evidence, inferences, redacted exhibits, direct and indirect evidence, all standard. Witness pretrial preparation, expert witnesses, all stuff that's right out of the model jury instructions. Electronic communications, jurors already got that one. Testimony and photographs with an emotional impact, same one from the first trial. John's pictures of John's death, autopsy, obviously. Confessions and admissions. So this was a new one. You have heard testimony about a statement. This was read to jurors already, though. You've heard testimony about a statement allegedly made by the defendant concerning the offense which is charged in this case. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all the surrounding circumstances. Karen's media interviews. So that's definitely coming in. And here's the big one, the big crescendo. We knew it was coming. Ladies and gentlemen, I called it. I told you the state was going to move for consciousness of guilt. I told you it was going to be witness intimidation too. I told you, ladies and gentlemen, you have heard evidence suggesting that the defendant may have intentionally tried to destroy, conceal, or falsify evidence in this case, and may have intentionally attempted to harass and intimidate witnesses whom the defendant believed would testify against her. If the Commonwealth has proof that the defendant did, you may consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on these charges. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all of the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. I caution you in considering such evidence that the defendant is not on trial for destruction of evidence, misleading a police investigation, or witness intimidation, and you are not to consider such evidence as a substitute for proof of guilt of the offense with which the defendant is charged. You may use such evidence only for the purposes I have instructed, that is, whether it shows a consciousness of guilt for the crime charged. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. So, folks, you heard it. If that gets read to the jury, Karen Reed is in a boatload of trouble. Karen Reed won't be sinking, ladies and gentlemen, or won't be swimming. She'll be sinking. Let me just tell you right now, ladies and gentlemen. Karen Reed, if that let me just tell you right now, if that instruction goes live, I swear to you, Karen Reed won't be floating. She will be sinking. Oh, Dr. Marie Russell parody account got gift memberships. I told you, folks, the gift memberships were going to start flowing because we have a little bit of a backlog. So if you're new to the channel, now's the time to join in. Become a towel subscriber. It costs nothing. You might get a free gift membership because we have so many backed up that almost anyone who joins with the gift membership setting turned on gets a new membership. So, love you all, ladies and gentlemen. We just got through the consciousness of guilt motion. You know what that means. We now got to move to the next development in the day because the consciousness of guilt motion was only the first such development during an otherwise wild series of events. So, of course, ladies and gentlemen, now let's take a look at when things just went absolutely chaotic, my dear towel friends, and that was when the motion for a mistrial was made. Now let me bring you to the moment that the motion for a mistrial was made. I have to mute this because we're going to use this feed because it's actually a useful feed. But before we actually go to the feed, ladies and gentlemen, I have to mute it so I don't accidentally play what plays on the X, which doesn't play on the YouTube, which is, but anyway, it's some music. But okay, so now we're taking a look for the moment right before we went to recess and then had to do the mistrial argument. So hold on, ladies and gentlemen, I think it was right here. So we're going to listen to the question that led the mistrial request to happen, and then we're going to watch the mistrial argument. Okay, so here we go.
Rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
Yeah, no. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Right. Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that fabric.
You're aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Get ready, folks, because now we go to protracted sidebar and watch what happens hold on, watch what happens the second we come back from sidebar. Bob Alessi becomes a Bob Alessi.
It's more 40 days.
Hold on. We're Bob Alessi become a Bob Alessi. Hold on. Where is it now? It's not that much further.
What did I say?
Oh, so the jury ends up. Okay, so hold on. So the jury gets sent off for morning recess. Hold on, I can't take a call right now. I'm sorry. Okay, let's listen.
No,
Watch
I don't have
this.
to talk. Thanks, Judge.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you. Brennan, can you remove? Oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Brennan.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, He has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript. I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour.
All right. Oh my goodness. Well, so much for Towel being asleep. Ladies and gentlemen, Towel's back. Oh, ladies and gentlemen, we've had a mistrial motion. The defense is desperate. Oh goodness, ladies and gentlemen, the Karen Reed defense is desperate. That was how Towel reacted in real. That was how Towel reacted in real time. And yes, my microphone is going. I think we have all let Towel know his microphone is going. But how do you think that went? Do you think Bob Alessi won? Oh, goodness, ladies and gentlemen. At 11:40, we came back into session. Are you ready for this? What do you think happened? It was moments on the mistrial motion. Oh my word, big moments in this retrial, ladies and gentlemen. I expect it to be denied. The votes are in, ladies and gentlemen. 96-4. 96-4, Little Towels. Oh goodness, mistrial motion. 96-4%, thinking that it will be denied. Little Towels are voting. Little Towels are. Here we go. With bated breath, ladies and gentlemen. Yeah, the Owlings incoming. Here we go.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah.
So then we end up finding that that opinion can't come in. But obviously Reed lost. Folks, it was 40 minutes of chaos as we waited for that. We got a 96-4 prediction. And, of course, Karen Reed lost the motion. But, yeah, I was just reflecting. You know, there's some moments in life where you're like, oh, I really want one thing. It would be so great to be such a welcoming chat, and then you screw it all up. But I know we're a welcoming chat. Colleen Henry, don't worry. If you ever see Alana again, just as a special favor to Towel, please be nice. It was Towel's fault. There's just a lot going on, and Towel's working on himself, okay? So please don't be mean. It was Towel's fault. Okay, so now we're going to take a look at what happened after that chaos, ladies and gentlemen, because then Hank Brennan got a little bit more time with Dr. Marie Russell, who said things like, I don't really understand text stream data. So let's listen to that part.
That one?
I was answering questions.
Do you know what the point was, what you were trying to deduce or
No, I was just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body brakes?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body brakes?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched a Lexus? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs, in dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. In reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog who bit John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Can I ask you differently?
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Oh, sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, and you wonder why, and you want to know, was the test done correctly, you know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with, and then of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please?
And then it gets even worse. Hank Brennan
Dr.
goes...
Russell, this is a photograph.
Sidebar. We go to sidebar, then it gets even worse. Hank Brennan goes from the no dog DNA to the pieces of taillight found in John's clothing. And ladies and gentlemen, we had a request from the Super Towel, honorary Super Towel spouse, Mandy Strong. And I have put it up on the screen right now, ladies and gentlemen. And that is the picture of the broken taillight from Karen Reed's Lexus in John O'Keefe's driveway at 8:23 a.m., ladies and gentlemen, on 1/29/2022. The little taillight is clearly broken, and the relevance of that, ladies and gentlemen, is Hank Brennan uses this evidence and more evidence to humiliate the next witness that we're going to watch Hank Brennan destroy, which was an officer who the defense, a police officer from Dighton, where Karen's parents who has been photographed, by the way, ladies and gentlemen, with members of the Free Karen Reed movement. And by the way, ladies and gentlemen, we are going to come back to that. We're going to come back to 44122 in today's stream, but let's take a look. First of all, ladies and gentlemen, let's take a look at the motion confirming that Brian Higgins, Brian Albert, and Michael Proctor will not be testifying in the John O'Keefe and Karen Reed retrial. And the way we can confirm that, ladies and gentlemen, is we just go right down here. We have a motion from the defense, ladies and gentlemen, and as you can see, this motion confirms. I'll bring it up on your screen and I'll zoom in because that helps to tell, friends. This motion confirms from the Karen Reed defense that the three people named in the motion, which is going to be Higgins, Michael Proctor, and Brian Albert. This is a motion moving for the state, for the Reed defense to be able to get a jury instruction about them not testifying, and that thus is confirmation, ladies and gentlemen, that Michael Proctor, Brian Higgins, and Brian Albert are not going to be called by the Reed defense and therefore will not be testifying in the John O'Keefe and Karen Reed retrial. All right, ladies and gentlemen, so we got caught up on that. And then also, let's take a look, ladies and gentlemen, at the picture of the next witness that we're about to look at, Michael Barros, one of the Dighton police officers. Ladies and gentlemen, let's take a look at the images of Michael Barros that we're seeing of, no, that's Bob Alessi with zippers over his mouth, ladies and gentlemen. Yes, ladies and gentlemen, God bless so many of you. There are definitely almost 20,000 total over on the Twitter. But yes, I am here being a super towel, and we are continuing. Ladies and gentlemen. Oh, we have questions of Karen. Oh, ladies and gentlemen, we have Karen Reed leaving court. Oh, look at that, ladies and gentlemen. Just seconds ago, we have video of Karen Reed leaving court. As we were getting ready to look at the next witness, we get a break with video of Karen Reed leaving court. Here it is, ladies and gentlemen.
Karen, are you definitely not testifying? Because we saw your suggested jury questions, or the jury instructions. It said, as you know, the defendant did not testify.
I don't even know. Oh, they're boilerplate.
Okay.
Those are boilerplate.
What about? Do you want to testify?
There's no, Karen. There's. I'm ambivalent, and by ambivalent, I could get on board with either one. I feel strongly either way.
How did Dr. Russell?
Excuse me. Fantastic. She's just honest and speaks from her experience.
What will the witnesses from the waterfall say tomorrow if they testify?
We'll have to wait and see. We'll have to wait and see.
How about the testimony?
Karen, why no request for a third-party culprit instruction in your jury instructions? Are you still going to argue third-party culprit?
I have not seen those instructions, so I can't answer to it yet.
How about the testimony today? What sort of stood out for you?
That the taillight was not completely smashed. I think the word the independent cop, as the prosecutor himself called him, was it was not completely smashed in or busted in at 3 p.m. as it went into state police custody. That's all that matters.
How did you feel when your
memory
Earlier in the day, he said it was.
Yes, it was after 5:07. Earlier in the day was 8:23. Brennan's last question was, did it look like the photo in the driveway at 8:23? Yes, it was broken already.
So when do you allege that your taillight was tampered with?
It's on video.
Oh my God, they're vultures. She's done. She's done. Oh, she's done. They're vultures, ladies and gentlemen. They're vultures. They're vultures. Vultures everywhere around Karen Reed. Oh, I've never seen anything like it. Oh, they vultured her. Vultures, ladies and gentlemen. Just pure vulture status. Oh, goodness. Yes, I agree with you, Breaking Forever. God bless you, friend. Thanks for joining us. What is it? Bear King Forever. What a wonderful username. I like that username. But yes, ladies and gentlemen, that was Karen Reed leaving court. Oh, it did not go well for Miss Reed. I can tell you right now, if the media is swarming you like that and you look like that, it is not looking good for you. Now, ladies and gentlemen, we are doing our update stream here, and of course what I was going to look at is the picture of that next witness, that independent cop, ladies and gentlemen. Oh, really? Let's see if this is indeed an independent cop, ladies and gentlemen. Oh, is it now, ladies and gentlemen? I don't think it is, but I can tell you right now there's one quick way to find out, ladies and gentlemen. And the quickest way to find out, we go over to the post. I think it was Carrie Lama that found the image. I think she had just posted it a little bit ago. I think someone linked us to it. Where is it now? She didn't delete it. It was the Barrios post. Does someone have a direct link to, I think it was Carrie Lama that posted. I think a towel friend had posted it in the chat. Hold on, ladies and gentlemen. Where is it? That was an incredibly useful post. I thought it was Mama Llama. Oh, thank you, DJ. I appreciate you, dear towel friend. Ladies and gentlemen, look at those towel friends. They are just on it. They're on it 24/7. They are super towels in every sense of the term. And that allows little towel to bring this up, ladies and gentlemen. Oh, didn't need to scroll down that far. Bring that up. Click that. Thank you to Mama Llama for finding this. So Carrie Llama, so I'm going to bring this up for us right here. Yes, lady. Oh, no, she deleted it. Oh, ladies and gentlemen, she deleted the picture. Oh, very interesting. Yes, but go to that link, ladies and gentlemen. It's deleted. You might be able to get a screenshot of it. I think I got a screenshot of it, but it's deleted. But yes, this next witness, ladies and gentlemen, this next witness certainly has some friends in the orbit of the Karen Reed movement, and I saw the picture myself. I saw the picture of Officer Barrios with two members of the Free Karen Reed movement. Now, how did Hank Brennan do on his cross of Officer Barrios? Well, let's just say Officer Barrios went down in flames, and basically he admitted he has a terrible memory and had no idea what he was testifying to. And so I have the literal moment that Hank Brennan's cross starts, which is 3:35 p.m. Eastern. So we just jump ahead. Look at how we jump ahead. We don't have to listen to Bob Alessi being a Bob Alessi. We just get to jump right ahead to 3:35 p.m., ladies and gentlemen. And now this should be the start of Hank Brennan's cross.
I'll be able to tell you. I can't.
I had it at 3:35. No, Hank Cross is done at 3:35. It starts at 3:04. All right, ladies and gentlemen, you're going to get to watch Mr. Hank Brennan do his cross of this officer, and let me just tell you, it goes really bad, really fast for the Karen Reed defense.
Sure.
Say just after 3 o'clock in the afternoon.
Absolutely.
All right, here we go.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Guyton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed?
Nope.
Or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but...
Did you at the time?
At the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted...
Hold on, we have to pause, ladies and gentlemen, because I found what I wanted to show you. Thank you to every single towel friend who reached out, ladies and gentlemen. You are all super towels, and let me just show you right now, ladies and gentlemen. We have the image. Here it is, folks. Does that look familiar to you? Does that look like an FKR account potentially posting a picture of Officer Burris, ladies and gentlemen? Barrios with FKR supporters, ladies and gentlemen. Oh, goodness, ladies and gentlemen. That, I don't know when that post was made by True Crime Gal, who's, I think, one of the FKR accounts. But, ladies and gentlemen, that is a bad, bad sign. Are you seeing what I'm seeing? Thank you to DJ. Thank you to the other Super Towel All of 19. Thank you to the Super Towel JVA. We found it, ladies and gentlemen. We are collective operational towels. Look at Officer Barrios with the FKR supporters. Ladies and gentlemen, generally, I'm a member of the media. I don't have ex parte contact with prosecutors, but I'm just putting this out there, ladies and gentlemen. I filed it under things in the John O'Keefe and Karen retrial that make me say, and there it is, ladies and gentlemen. You can see it. There it is, at Notorious FKR account posting a picture of Officer Barrios with two FKR supporters within recent memory, ladies and gentlemen. Within recent memory, there it is. Right up on the screen, no doubt about it, ladies and gentlemen. We can zoom in a little bit more if you want to. We can, I mean, if you really want to make sure, but it's him, ladies and gentlemen, unless, obviously, ladies and gentlemen, this was an image that was shared online, but, you know, that bears a striking resemblance, ladies and gentlemen, to Officer Barrows. So let's take a look here. What do you think? What do you think, ladies and gentlemen? You want to do some towel analyses? Let us zoom in, shall we? Is this the man testifying on the stand? I mean, it literally identifies him as Officer Barrios. I was saying Barrios, but is that him? Ladies and gentlemen, is that him? I mean, it's a pretty striking resemblance there, ladies and gentlemen, and, you know, can continue zooming in, but it is definitely interesting. It is certain, and we're going to go back to the cross, but So that is the relevant person, ladies and gentlemen, is, yeah, you know, but it identifies him it looks like he has a beard in that photo, but it identifies him as Officer Barrows. So obviously, you know, the post was a repost of someone else's post, but a lot of people, you know, I think, and obviously it identifies him as Officer Barrows, so. But yes, we're going to go back to the cross, you know, ladies and gentlemen. A lot of people are making the argument. It certainly, the post, now again, there could be an image on another post, but the post identifies this person as Officer Barrows. But again, this was a post that was reshared. So yeah, I'm not sure. It's from June of 2024. Not sure who this gentleman is. Feel like I've seen him. Not sure who this woman is. So yeah, there you go, ladies and gentlemen. Oh, okay. But there you go, ladies and gentlemen. Now we are going to go back to listening to Hank cross this man, and it does look like it's him. Looks like he has a hat on in this picture. That's the only thing that's different. I mean, ladies and gentlemen, that is a pretty striking resemblance, I will say. And obviously, I think most people are going to make a pretty compelling and strong argument that it's him. So what we're going to do is we're going to bring this over to its own little page here, ladies and gentlemen, and then as Officer Barrows continues his testimony, I think what we'll do is we'll just have that image up next to him. So you all keep chatting away. Let's take it away, Hank.
It's fair to say you only wrote one single line about the damage to the car.
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did. The right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't?
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
What were you asked about to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed.
Time has passed, yep.
That you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed.
Correct.
That your report was respectfully scant.
Correct.
But you had heard a lot about this case since that point, hadn't you?
Correct.
And so, considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer, and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification for the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, don't. Okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
Sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
The good-looking one down there on the right?
Oh, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came into court?
No.
The photograph of the vehicle in Sallyport, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
You were asked to describe the damage, and you were shown that photograph. You never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
All right, now, friends, we're going to continue this cross, but I just want to let you know, towel friends, thanks to the Super Towel themselves, DJ, we, ladies and gentlemen, were able to get a copy of the original post. There it is, ladies and gentlemen. Take a look. I have to cover your comments for a second. There you go. You can see those are pictures, ladies and gentlemen. Officer Nick Barrows, June 2024. Oh, ladies and gentlemen, my word. This man has deeper connections to the Free Karen Read movement than it may appear, and you can see it right on your screen. So we're going to keep that image. That's the original post. Super Towel DJ coming through with the find. And ladies and gentlemen, let's finish up Hank's Cross, because this is basically how the day ended.
So, in your memory, in June 10, 2024, was that vehicle's rear tail light had a piece missing, correct?
Correct.
You said that your memory about the damage to the tail light, as you recall it when you were in Dighton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right? Yes.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at there, could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29, 2022?
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that on the road you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah. Correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
So that, okay.
Over here.
So we're going to jump forward to see the end of Hank Brennan's cross.
That, folks.
Hold
Hank
on.
Brennan said, over here, Alan Jackson.
Oh, that's when it happened. Hold on, watch this. That was a moment. Hank Brennan was like, look over here.
To go to sidebar.
Hold on. Watch this. You got to listen pretty carefully.
To go to sidebar.
Hold on.
To go to side.
No, I want to go a little bit prior back.
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
So that,
So it was very soft, but Brennan said over here, telling the witness, because look at the witness' eyes. He's looking over at Alan Jackson. And so Hank Brennan thought the witness was being coached. And so Brennan was like, look over here. And then Alan Jackson called for a sidebar. Did you all catch that? It was very subtle, but I caught it.
okay.
Over here.
And then, hold on, did you hear at the very end there, before I say to go to sidebar, you hear Alan Jackson say, over here, when Brennan's walking over to sidebar, you could tell he was pissed.
Okay.
Over here.
Did you hear it? He's over here. Hold on, one more time.
Summons to what my schedule was like coming up in the next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about? Objection.
I'm going to allow it.
Over here. What did you talk about? Excuse me.
So that, okay.
Over here.
Over here, Jackson was pissed, ladies and gentlemen, and I could hear it at the time, as could the rest of us. It was a quick sidebar.
Had a bad memory.
Oh, and then the bad memory
Details
questions was
about
even worse. It got
Karen
worse and
retrial.
worse.
Oh, Hank Brennan
I was
sidebar
just
W20.
yelling.
We're going to moment about to come defense, and then AJ demanded a sidebar. Moments, scenes. Here we go.
You told us there was some background about being subpoenaed and timing. Substantively, what did you talk about with the attorneys when you met them at their hotel conference?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this
probably June, early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably? Do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV, and
Was it shown to you during your conference room meeting at the hotel?
it was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations in Dayton on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
Yeah, if you approach after she already allowed it, you're screwed. Oh, Hank Brennan is just destroying this witness. This witness clearly changed his testimony from the first trial, clearly met with the defense. Oh, this has gone down in flames again for the defense. You can't play Hank Brennan. Are you some kind of fool? We're at side bar, ladies and gentlemen, creeping towards the 4 p.m. potential end of court. Who knows where this is going to go? Ladies and gentlemen, Alan Jackson just lost, and now he wants a sidebar. It was quick. I'm going to guess he was told he lost, and now Hank Brennan's going to get to re-ask his devastating question. There's Karen Reed. I'm a towel. There's Chloe the dog in a wig. I am a towel. Hank, we know you're ready. We know you're willing. We know you are a super towel. Take it away. Come on, Mr. Brennan. The world awaits your decimation of the Karen Reed defense witness who clearly changed the story.
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dayton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Okay. Before you proceed, Ms. Gunner, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look compared to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. Who's way this way? Stop, please. Do you see that white part of the back mirror right there? Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
Can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop it. Can you bring it back to someone? Back one. Hold it right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton. Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear tail light and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay.
No.
Did I show that?
No. I did.
Did you tell me your availability and willingness of such testimony was from last Sergeant Barrows, 29th, difficulty whatsoever. The
has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear tail light, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
That was the end. All of 19, there's only one defense amended witness list, and it just has Trooper Proctor's friends on it. So there's no witnesses other than Trooper Proctor's friend, only one of which was called, and the defense witness list. And by the way, you don't actually submit a defense and prosecution witness list, you submit a combined witness list. But anyone on the combined witness list is on the formal trial witness list, along with Michael Proctor's friend, who already was called. So, ladies and gentlemen, you saw it. You saw the full Hank Brennan decimation, and that was how the day ended, ladies and gentlemen. And obviously, Officer Barros, we have the pic right here, ladies and gentlemen. You can see it. No, I think more, Wicked Uma, you're talking about the video where they pick up the car, where they originally arrived to pick up the car after 12 p.m. on 1/29/2022. I wouldn't say he packs it. He more kind of like, what I think him or his father wipes snow off it at some point. I mean, we can watch that video if you want. So hold on 1 second, Wicked Uma. Let's finish the recap, Wicked Uma, and then we can watch the question. I guess it's actually related to Barros's testimony. So hold on, Wicked Uma, you have a question. I'm glad it got paused on the screen because, my dear towel friend, as a result of it getting paused on the screen, I was able to see it, bring it up, and I don't want Bailey's comment to get missed, ladies and gentlemen. Bailey is a super towel. Yes, hi Eva. Yes, we're just finishing the recap. We have one request, and we got to remember we're keeping towel. We're not keeping towel, but we're trying to keep towel healthy. So, but yes, we have a request from Wicked Uma to look at the video of the brother. So we're gonna do it, ladies and gentlemen. We're gonna do it. Hold on 1 second. Hold on, and don't ever feel bad about making a request because it is relevant about the state of the taillight as it was broken leaving John's house versus arriving at Karen's parents' house sometime, ladies and gentlemen, I'd say after 2 p.m. on the afternoon of 1/29/2022. So let me just pull this up for you. Hold on 1 second. Hold on. Let me see if I got the video. Is this, I have to check to make sure this is the actual video. Hold on. Let's see. Hold on. This is just the testimony. That's not what we want. What I want is yeah, I got it. I got the video for you. I got it for you. See, Wicked Uma? I'm a super towel. You asked Towel's memory has it, and I think this is where I also asked Nathan Reed if he was an accessory after the fact.
You know, I want to ask you if you were an accessory after the fact, Mr. Nathan Reed.
Could you stop that video? Do you know who that is?
I believe that's the defendant.
Continue, please. Could you stop that? Do you know who exited the car?
I believe that's Mr. Reed.
Okay, continue, please.
This is hours before Dayton, by the way.
Thank you. Did you continue to watch the video from the driveway?
Yes.
During that time period?
Yes.
Did you see anybody else get out of that car that was in the back?
Yes.
And who did you believe you saw getting out of that car?
I believe it was the defendant's brother and possibly his companion. I don't know who that is.
Did you have a chance to watch the video?
Yes, I did.
At 12:35 p.m., could you play video 174, please?
There you go, Wicked Uma. Yeah, he doesn't really pack it. Yeah, he brushes off the windshield. and he avoids brushing off the tail light. That's what he does. He brushes off everything but the tail light area. And then he cleans the front of the car. Yeah, I'll take a look, Christina.
Thank you. Did you?
So you can see right there, it's very clear that Nathan Reed continues.
You look at video from 1240.
Yes, I did.
Could we have video 171?
Bill and Nathan Reed. Maybe Karen. It's, yeah, Nathan Reed on the right, Bill Reed on the left. Again, wiping everything but the taillight. That's Nathan's wife, Kristen Bordeaux, getting out of the back car, walking forward. Caitlin Bordeaux.
And 175.
Nathan Reed again. Interesting part. Not this part, but wait till you hear what the trooper says next.
Thank you. Did you look for further video to see if there was any video for the time around when the Lexus was taken from Meadows that morning?
Yes.
Was there any video that was produced that shows the time around before and the time that Lexus was removed from that driveway that morning?
There was no video, no.
Boom, they deleted that video of them leaving too. 17 videos from 5:07 to 12:18, and then that video as well. Oh my goodness, Towel friends. Wow, 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 wow. And yes, Bill Reed did admitting to wiping snow off the bumper when I was outside court with him that day, ladies and gentlemen. My name is Grant Smith Ellis, by the way, and it has been a long day. It has been a long day. Ladies and gentlemen, we have done our recap, folks. I appreciate every single one of you who tuned in. We will check out some of the new motions tomorrow morning. There's a motion about like a limiting witnesses' testimony, ladies and gentlemen. And then, of course, we will be back at 7:30 a.m. Oh, we're going to do a special towel stream tomorrow at 7 a.m., bright and early. We have a half day of court tomorrow. Are you excited? I'm excited. And listen, ladies and gentlemen, I know how much it means for you all for Little Towel to have a positive attitude. And listen, I am fallible. I am a human. I walk amongst this earth just like every one of you, and I want to promise you that even if Little Towel has a bad day, even if Little Towel is a little bit stupid socially sometimes and emotionally and has bad executive function, I truly care. I come from a good place. I want to be a better person. I want to be a better towel, and I want to get better. So don't fawn over me. Please learn to think for yourselves. Empower yourselves with this information. Don't be obsequious. Don't, even to me, I know all of your support for Little Towel is not gratuitous. You all truly mean it. I truly care about so many of you. But I also know that a positive towel atmosphere is what we all want to see. But know that even in your down moments, whether it's big towel, little towel, or the towelettes, or washcloths, soap dispensers, flannels, hemp towels, paper towels, beach towels, microfiber towels, or otherwise, you can have a down day. That's what makes you special as you. It's how you respond. It's how you react. It's how you learn. And it's where you were coming from that matters, ladies and gentlemen. And that is how we as Towel Souls continue to talk about the John O'Keefe and Karen Reed retrial from a respectful place of reverence, ladies and gentlemen, from a place of compassion and universal toleration and unconditional love. And ideally, ladies and gentlemen, from a place of informed public discourse such as to ward off usurpation of our representative forms of government and their constituent branches, in particular the judicial system. Now, my name is Grant Smith Ellis, and if you've been enjoying this recap, please give the stream a like, subscribe to Towel Channel. We've been going for about 10.5 hours now, so not too long. That gives me a little bit of time to go out, get a snack, ready the recap. I'll upload that when I get back. I'll get some rest. We'll be up. We'll see each other at 7 a.m. tomorrow. Join us again, youtube.com/@GrantSmithEllis, and thanks for watching this recap. I have to note the end of the time of the recap because I have to go talk to the Towel friends. 5:59:15. It's actually going to be 5:59:20 because that's even better. So that's not bad. Our recap started at 5:13. We were done at 5:59 and 30 seconds. Wonderful, Towel friends. That's not bad. Hour and 30 minutes. Bang it out. All of 19. Oh, don't make me tear up. There's nothing that makes me tear up like a super hippo. Little Towels, you know what? That little super towel hippo, look at him. He's saying to Little Towel, you are a rock star. Well, you, Little Towel hippo, you're a rock star. Look at, ladies and gentlemen, look at me giving that Little Towel hippo a Little Towel hippo rub. Oh, God bless you, Little Towel hippo. But yes, ladies and gentlemen, that was the end of the recap. So thank you all for tuning in. And you know, ladies and gentlemen, you know that I am about to say our closing because we're not going to be gratuitous. We're going to keep Little Towel healthy, and we're going to see each other super out early in the morning tomorrow. So we're going to